Okay, reading Barbri, Real Property Outline on page 122, starting with recording. At common law, in nearly all cases, priority was given to the grantee first in time to record. Thus, if O conveyed Blackacre, let's not even bring a recording into this. First in time has priority. Thus, if O conveyed Blackacre to A and then made an identical conveyance to B, A prevailed over B on the theory that after the first conveyance, O had no interest left to convey. 1. Recording acts in general. Statutes known as recording acts require a grantee to make some sort of recordation so as to give notice to all the world that the title to certain property has already been conveyed, and thus to put subsequent purchasers on guard. These statutes are in effect in some form in every state. Basically, recording acts set up a system by which any instrument affecting title to property located in a certain county can be recorded in that county. These acts seek to protect all subsequent bona fide purchasers from secret, unrecorded interests of others. A. Purpose of recordation is notice. Recordation is not essential to the validity of a deed as between the grantor and grantee. However, if the grantee does not record her instrument, she may lose out against a subsequent bona fide purchaser. By recording, the grantee gives constructive or record notice to everyone. Hence, as stated earlier, proper recording prevents anyone from becoming a subsequent bona fide purchaser. Requirements for recordation. What can be recorded? Instrument affecting an interest in land is 1, and 2, grantor must acknowledge deed. So under 1, practically every kind of deed, mortgage, contract to convey, or other instrument creating or affecting an interest in land can be recorded. Note, a judgment or decree affecting title to property can also be recorded, and even before judgment, where a lawsuit is pending that may affect title to property, any party to the action can record a lis pendens, notice of pending action, which will effectively put third parties on notice of all claims pending in the lawsuit. And 2, grantor must acknowledge deed. Most recording statutes provide that, in order to be recorded, a deed must be acknowledged by the grantor before a notary public. This requirement offers some protection against forgery. Problems may arise if the recorder records a deed that has not been acknowledged or has been improperly acknowledged. C. Mechanics of recording. Filing copy. 1. The grantee or her agent normally presents a deed to the county recorder, who photographs it and files the copy in the official records. These records are kept chronologically. Indexing. The recorder also indexes the deeds to permit title searches. The usual indexes are the grantor-grantee and grantee-grantor indexes, which are arranged by reference to the parties to the conveyance. Tract indexes, which index the property by location, exist in some urban localities. 2. Types of recording acts. There are 3 major types of recording acts, classified as notice, race notice, and race statutes. Note that the burden is on the subsequent taker to prove that he qualifies for protection under the statutes. Notice statutes. Under a notice statute, a subsequent bona fide purchaser, for example, a person who gives valuable consideration and has no notice of the prior instrument, prevails over a prior grantee who failed to record. The important fact under a notice statute is that the subsequent purchaser had no actual or constructive notice at the time of the conveyance. Constructive notice includes both record notice and inquiry notice. A typical notice statute provides a conveyance of an interest in land other than a lease for less than 1 year shall not be valid against any subsequent purchaser for value without notice thereof, unless the conveyance is reported. Also note that the subsequent bona fide purchaser is protected regardless of whether she records at all. So the subsequent bona fide purchaser is protected regardless whether she records at all if she bought the title without notice. For example, on January 1, O conveys Blackacre to A. A does not record. On January 15, O conveys Blackacre to B, who gives valuable consideration and has no notice of the deed from O to A. B prevails over A. What if A records before B? Suppose in the example above that A recorded on January 18th and B never recorded. This is irrelevant under a notice statute because B had no notice at the time of her conveyance from O. B is protected against a prior purchaser even though B does not record her deed. This is the difference between notice and race notice statutes. Of course, if B does not record, she runs the risk that a subsequent purchaser will prevail over her, just as she prevailed over A. B. Race notice statutes. Under a race notice statute, a subsequent bona fide purchaser is protected only if she records before the prior grantee. Rationale. The best evidence of which deed was delivered first is to determine who recorded first, to obviate questions about the time of delivery, and to add an inducement to record promptly. Race notice statutes impose on the bona fide purchaser the additional requirement that she record first. A typical race notice statute provides any covenants of an interest in land other than a lease for less than 1 year shall be valid against any subsequent purchaser for value without notice thereof whose conveyance is first recorded. Okay, moving on to page 124 is an example. On January 1, O conveys Blackacre to A. A does not record. On January 15, O conveys Blackacre to B. On January 18, A records. On January 20, B records. A prevails over B because B did not record first. Race statutes. Under a pure race statute, whoever records first wins. Actual notice is irrelevant. View rationale is that actual notice depends on the extrinsic evidence which may be unreliable. Very few states have race statutes. On January 1, O conveys Blackacre to A. A does not record. On January 15, O conveys Blackacre to B. B knows of the deed to A. B records, then A records. B prevails over A because she recorded first. It is immaterial that she had actual notice of A's interest. Who is protected by recording acts? Only bona fide purchasers are entitled to prevail against a prior transferee under notice and race notice statutes. To attain this status, a person must satisfy 3 requirements, each of which is discussed in detail below. Be a purchaser or mortgagee or creditor if the statute so allows. 2. Take without notice, actual, constructive, or inquiry of the prior instrument. And 3. Pay valuable consideration. Note, if these requirements are not met, the person is not protected by the recording acts, so the common law rule of first in time prevails. O. The owner of Blackacre executes a contract of sale of land to A on Monday. A immediately records the contract. On Tuesday, O deeds the land to B. B pays valuable consideration for the land, but is not a bona fide purchaser because B is held to have constructive notice of A's rights. Results. A is entitled to enforce the contract against B, paying B the rest of the price and compelling B to deliver a deed to A. If A had failed to record the contract and B had no other notice of it, B would have taken free of A's contract rights. A would have an action in damages against O for breach of contract, but would not have a claim for specific performance against B. Purchasers. All recording acts protect purchasers of the fee or any lesser estate. Donees, heirs, and devisees are not protected. Donees, heirs, and devisees are not protected because they do not give value for their interest. O, the owner of Blackacre, conveys it to A on Monday. A fails to record. O dies on Tuesday, and his heirs, devisees, succeed to his property interest. Even though O's heirs, devisees, may be unaware of the prior conveyance of Blackacre to A prevails. Purchaser from donee, heir, or devisee. A person who buys land from the donee, heir, or devisee of the record owner is protected against a prior unrecorded conveyance from the record owner. Example: O conveys Blackacre to A, who does not record. O dies, leaving H as her heir. H does not prevail over A because he is not a purchaser. H conveys to B, a bona fide purchaser who records. B prevails over A in nearly all jurisdictions. An heir who purchases the interest of her co-heirs without notice of the prior unrecorded conveyance is entitled to the same protection as any other purchaser to the extent of her purchase. And C, mortgages. E's. Mortgagees for value are treated as purchasers, either expressly by the Recording Act or judicial classification. Judgment creditors. In nearly all states, the plaintiff who obtains a money judgment can obtain, by statute, a judgment lien on the defendant's real estate. A typical statute reads as follows: any judgment properly filed shall, for 10 years from filing, be a lien on the real property then owned or subsequently acquired by any person against whom the judgment is rendered. Is a plaintiff who obtains a judgment lien under a statute protected by the Recording Act from a prior unrecorded conveyance made by the defendant. The cases are split, but the majority holds that the judgment lienor is not protected. These courts usually reason either: Romanet 1, the plaintiff is not a bona fide purchaser because he did not pay value for the judgment, or 2, the judgment attaches only to property owned by the defendant and not to property the defendant has previously conveyed away, even if that conveyance was not recorded. 5. Transferees from bona fide purchaser shelter rule. Person who takes from a bona fide purchaser will prevail against any interest that the transferor, bona fide purchaser, would have prevailed against. This is true even where the transferee had actual knowledge of the prior unrecorded interest. Example: O conveys to A, who fails to record. O then conveys to B, a bona fide purchaser who records. B then conveys to C, who has actual knowledge of the O to A deed. C prevails over A, and this is true whether C is a donee or a purchaser. The rationale is that if the rule were otherwise, a bona fide purchaser might not be able to convey an interest in the land. The transferee is not protected for her own sake, but rather for the sake of the bona fide purchaser from whom she received title. Exception: no shipping through. This rule will not help someone who previously held title and had notice of the unrecorded interest. In the example above, if O repurchased from B, O would have notice of A's interest and could not claim the benefit of the shelter rule. Purchaser under installment land contract. In most states, a purchaser who has paid only part of the purchase price under an installment land contract is protected by a recording act only to the extent of payment made. In a dispute between the contract purchaser and a prior claimant, the court may: Romanet 1, award the contract purchaser a share of the property as tenant in common equal to the proportion of payments made. 2, award the lien in a prior claimant to the prior claimant, but give the contract purchaser a lien on the property to the extent of the amount paid. And 3, award the land to the contract purchaser, but give the prior claimant a lien on the property to the extent of the balance still owed. This is in Sparks v. Taylor of Texas, 1906. O conveys Blackacre to A, who does not record. O then conveys Blackacre to B as a gift. B, knowing nothing of the O to A conveyance, records her deed. B then sells Blackacre to C for $100,000 via an installment land contract. C is to make 4 payments of $25,000. C makes the first payment and records his deed. A learns of the B to C conveyance and files suit against C to quiet title. Result, the court may award C a 1/4 interest in Blackacre as a tenant in common. Romanet 2, award Blackacre to A, but order A to pay C $25,000, or Romanet 3, award Blackacre to C, but order C to pay the remaining $75,000 to A. Exception, shelter rule. If B in the example above were a bona fide purchaser, the shelter rule would apply, and C would be fully protected even though C had notice of the O to A conveyance partway through C's payment. B without notice. So, again, this is a purchaser under installment land contract. This time, instead of applying the shelter rule exception, we are reading without notice, which means that the purchaser had no actual record or inquiry notice of the prior conveyance at the time she paid the consideration and received her interest in the land. While no one has a legal duty to perform a title search, a subsequent purchaser will be charged with the notice that such a search would provide, whether or not she actually searches. However, the fact that the purchaser obtains knowledge of the adverse claim after the conveyance, but before she records it is immaterial. She only has to be without notice at the time of the conveyance. So there's an actual notice, record notice, chain of title, which discusses wild deeds and deeds recorded late, is also under the record title, chain of title. So these are chain of title problems. So for actual notice, the subsequent purchaser must show that she did not actually know of any prior unreported conveyance. Actual notice includes knowledge obtained by any source, the newspaper, word of mouth, etc. Record notice points to the chain of title. The fact that a deed has been recorded does not always mean that the purchaser will be charged with notice of it. A subsequent purchaser will be held to have record notice only if the deed in question is recorded in the chain of title, which means that it is recorded in a fashion that a searcher could reasonably find it. There are several situations in which a deed might be recorded, but very difficult or impossible for a search to locate, where we discuss wild deeds, deeds recorded late, deeds recorded before the grantor owned title, deed in chain referring to instrument outside chain, restricted covenants, deeds from a common grantor, and marketable title acts, which seem to create a statute of limitation to the chain of title. And then we can go into what is inquiry notice, valuable consideration, title search, effective recording before reaching conveyance by will, which is another section.